have Natasha Ballard versus D23 LLC.
I'm here. Thank you.
Your box is identified as V20. Are you, when you said I'm here, are you Natasha Ballard, ma'am?
This is Ada Apati for the respondent, D23 LLC.
Hi, Ms. Akpati. How are you?
I'm fine, thank you, Your Honor.
Thank you. Again, the person who just spoke and said I'm here, is that Natasha Ballard? Uh-oh, I think we've lost that person.
Okay. Oh, all right.
Mr. Freoff, you're not muted. Okay. Ms. Akpati, if you can be patient with me for just a minute. I think the impression I got was that person was Natasha Ballard identifying themselves. So I'm going to give them a few minutes to see if they can rejoin the call. And then we'll go from there. If you don't mind, feel free to mute or, whatever while we wait. Okay.
Yes, Your Honor. I did want to say that we did want to request for, to see if we could reach a settlement.
Oh, it's like a breakout
Ballard.
room so you could talk
Yes.
if she comes back?
Yes,
Happy to do that if we can get Miss Ballard. Looks like we maybe do have her back on the call. Miss Ballard, are you there? I'm sorry?
This is from Dar Jaripati. It's D23, but I do have my counsel, Miss Ada, on the call as well.
This is Miss Ballard. I'm back. I was sent to a breakout.
Yeah, I think Mr. Freoff created a breakout room and maybe everybody went to join it, and it really should only just have been those three people. So I apologize for that. Ms. Ballard, Ms. Akpati and Mr. Is it Jadapati? Is that correct?
Yes, Your Honor.
Those individuals are here on behalf of D23 LLC, and they were asking if perhaps I could put you guys in a breakout room to discuss whether or not, just briefly discuss whether or not there might be some agreement that y'all could come to. Is that something you would be willing to do, Ms. Ballard?
No, not at this time.
Okay. Ms. Akpati? That's the announcement I've gotten. So can you tell me, Ms. Ballard, what I'm not going to call your case formally right now. Right now, what I'm looking for is how long do you think that it will take to present what you want to present to the court today?
To my understanding, has the court reviewed the affidavits that has been submitted?
Yes, ma'am, I have.
Okay. So what can I expect as far as procedure? How will this hearing go?
Well, so typically what will happen, because you are the movant, you're the person who's seeking relief. So I would call on you to make any presentation that you would want to make. Sometimes people choose to do that. Some people don't choose to do that. But the idea is that if you wanted to explain to me what your position is in some shorter or different way from how you put it in the filings that you made, and then I would call on Ms. Akpati on behalf of her client to make a response. And then typically, because you're the movant, I would let you have the last word. And then sometimes I rule during the hearing. Sometimes I take it under advisement. It just depends on the circumstances. But right now, at this part of the hearing, what I'm typically doing is just asking the parties to tell me, how long do you think it will take if you wanted to make a presentation to me, Ms. Ballard, or if you want to rest on your briefs, you can do that.
All right, folks, buckle up, because we are diving into a wild ride of courtroom chaos. Right from the start, you can tell this is not your average landlord-tenant dispute. Natasha Ballard is here, claiming she has priority interest in the property, denying she's a tenant, and challenging the opposing party's authority. On the other side, we have D23 LLC and their attorney, ready to uphold the magistrate's prior order. Already, you can feel the tension bubbling, miscommunications, breakout room chaos, and technical hiccups all setting the stage for a drama-filled hearing. What's really at stake here? Money, possession, and legal interpretations of contracts, or the lack thereof. Throughout this hearing, watch for how procedure, evidence, and persistence collide with courtroom reality.
Natasha Ballard versus D23 LLC, which is an appeal from a dispossessory order in magistrate court. Ms. Ballard, as I mentioned, I have reviewed the petition that you filed with the affidavit that was accompanied it. And so did you wish to make any oral presentation here at the hearing, or do you want me to rely on what you have submitted in your briefs, which again is fine. You may do whichever you wish.
Sure. So from my position, I filed an affidavit of priority interest, in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity. I'm requesting that this motion under the titles, under the Rule 60V, this is thrown out. It just, we don't have a contract. There's nothing to really argue here. So, it's clearly displayed and stated in the affidavits that I submitted. And bottom line, we don't have a contract. The other entity does not own.
Here's where it starts getting interesting. The term sovereign citizen pops up, which already tells you this case is not going to follow standard landlord-tenant logic. Sovereign citizens often deny government authority or contractual obligations, and that's exactly what Natasha is doing. She's arguing she's not a tenant, that no contract exists, and that the sheriff's deed isn't legally binding. From a legal standpoint, this is a huge uphill battle. Courts rarely recognize these arguments because they challenge the very foundations of property law. But from a viewer perspective, it's fascinating to watch how someone tries to navigate or even sidestep the system entirely.
And you're challenging that order. And I understand that part. But part of the order also requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put an affidavit to ask for rent. So, and there's no contract. But I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it. It's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order.
Now, watch how procedural chaos adds drama to this hearing. A breakout room mix-up leaves parties disconnected. Something that seems minor, but in the context of legal proceedings, it can affect how evidence is presented or even perceived. Courts rely heavily on clear procedure, and even brief interruptions can create confusion or frustration. The judge shows patience, allowing the parties to reconnect, which underscores how important timing and communication are. Meanwhile, as a viewer, you get to see the human side of law, the interruptions, apologies, and attempts at fairness that rarely make headlines. This also sets up the tension between what is filed on paper versus what actually happens live in court.
I have looked in both the magistrate court file, which is often where those payments will go, and I've looked in this action. And the financial documents don't indicate that any payment has been made in either case, other than the original, I think, $103 filing fee that was paid by the defendant in the magistrate court. By the defendant D23, the filing fee. Ms. Ballard, do you have any documentation? I'm looking at the file and I don't see anything that indicates payment. I'm happy to follow up with the court because sometimes the clerk it gets a little bit behind, but do you have any documentation regarding when you made those payments or the amount of the payment?
It was a couple weeks ago when I filed it into the court of registry.
Okay, what did you file? Did you file like a proof of payment or what did you file?
It is basically a money order.
I apologize. I need to take a brief break for something. Hold on just.
Here's a critical moment. Natasha decides to rest on her affidavit and filings rather than make an oral argument. Strategically, this can be risky, especially in a case where clarity and documentation are essential. Courts often give weight to in-person testimony because it allows the judge to assess credibility and clarify confusion. By choosing not to speak further, she limits her ability to respond to counterarguments immediately. On the flip side, sticking to the written record ensures no accidental misstatement under pressure. This is a classic example of the balance between legal procedure and courtroom strategy, and it gives us a glimpse into how high-stakes disputes hinge on small procedural choices.
Issue with it being credited to the wrong file or something like that. But absent any such documentation, there's no evidence that the required payment has been made either into the magistrate court or into the superior court file. And absent that payment being made, the order that was entered very clearly says that if tenant appeals the judgment and wishes to remain in possession of the property, those payments must be made. And so that would typically mean that the dispossessory order would be issued in stanter and D23 LLC would be entitled to possession of the property in stanter, which, would mean immediately. Do you have any additional documentation that you could perhaps email to Mr. Freehoff and copy Ms. Akpatian so that I could see it and then follow up with the clerk regarding what happened to a payment that you made?
So I tendered a payment into the court of registry. If my payment was not accepted, I would not have received a case number for this case right now. The payment was accepted. It had to have been in order to get this case number.
Actually,
so I have to feel bad.
Actually, that's not correct. So the file indicates, Ms. Ballard, the file indicates that you submitted an affidavit.
Now, Natasha ramps up the drama, claiming priority interest in the property and challenging the jurisdiction of D23 LLC. She's arguing that no tenant contract exists, and therefore the other party's claim is invalid. This is a classic sovereign citizen tactic, questioning the legitimacy of traditional property claims. Notice the tension as she cites the sheriff's deed as merely color of title, not true ownership. For viewers, it's fascinating because of the mix of legal terminology and courtroom theatrics. You can almost feel the clash of perspectives, formal law versus alternative interpretations of property rights. The judge listens patiently, which highlights the challenge of balancing fair hearing with legal reality.
The payment, and I don't know if there's some type of mix-up between both courts, but I filed it in both courts. The tender payment is there respectfully. Otherwise, I would not have been able. They even said this has to be satisfied in order to get a new case number for this appeal.
Ms. Ballard, I understand that. All I'm asking is, can you tell me what was the amount? When was the payment? Where did you get the money order from? That's the type of information that I would then be able to go to the clerk and confirm that information. And then they might be able to track the payment and figure out where it went if you made the payment.
All right, can you hold one moment while I get the information? Thank you kindly. Okay. So
Yes, ma'am.
I filed a notice of tender payment into the courts, and so to settle this account, I did file tender payment to the courts, and I'm sure you can see the affidavit in there, and it has proper endorsement. It's been properly endorsed, and if you like,
Ms. Ballard, can you tell me the case number on that? Is it this case number 2023 CV 390-111, or is it the 23 ED 284-322 case number?
It's 23 ED 284-322.
Okay. Give me a moment to look in the file and see what I can locate. Okay. Give me just a sec. Filing that I think that Ms. Ballard was referencing, which is a notice of tender of payment to settle and close account.
Yes.
And is that the thing you were referencing, Ms. Ballard?
Yes. Yes.
Okay. That was filed. It was filed in the magistrate court on December the 12th.
Yes, that is correct.
Okay. My review of the notice that you filed. So first of all, I've spoken with the clerk of court, and they have no record of any payment. They have looked everywhere they can think of, including associated with your name, associated with this case, associated with the Superior Court case, and they can find no record of payment. But more importantly, Ms. Ballard, my review of your filing seems to indicate that you are rejecting the acknowledgement that there is that money would be any like it doesn't appear that you actually submitted legal tender of any sort to pay or satisfy.
Here's where things get really tense. Payments into the court registry become the focal point, with conflicting statements from the parties. Ms. Ballard claims she has continuously paid, while D23's attorney asserts no payment is on record. This is more than an accounting dispute. It's a pivotal legal issue. Courts require clear proof of payment to maintain appeal rights, and a lack of documentation can derail her arguments entirely. From a commentary perspective, this is pure courtroom drama. Conflicting narratives, procedural rules, and the stakes of possession and money all colliding. Viewers can see how critical paperwork, timing, and record-keeping are in legal disputes, often more than the arguments themselves.
Other than the motion that you filed regarding the lack of payment and your statements here that there has not been a payment, what is your position on behalf of your client on this matter?
My position is that this matter should be dismissed. The Ms. Ballard has to comply with the order of the court before filing this appeal.
Okay. Ms. Ballard, I understand. I find, first of all, thank you for helping me understand what it was you filed, because originally when you were saying a money order or something like that, I was looking and I was not finding. And so I have reviewed what you filed now that I understand what I was supposed to be looking at. And, due respect, ma'am, but it is not filing a paper that says I hereby tender payment that is not actually accompanied by a payment recognizable in legal acceptable tender in the United States. Then you have not made a payment under any legal definition that I am aware of. And so as a result of that,
What species?
Excuse me, Ms. Ballard, I'm speaking, and in a moment I'll let you respond if you would like, but you have to let me finish.
Sure. Thank you.
So as I was saying, the motion, I think, is to dismiss the appeal of the dispossessory and to issue a dispossessory affidavit in stanter, which would seem to be appropriate here because there's been no payment made. And in the absence of a payment, there can be no appeal. And that is the position that D23 is taking. Would you like to respond to that before I rule, Ms. Ballard?
Yes. So, on the order, it did not specify how to pay. What species of payment is on there to pay? It was not specific.
I'm sorry, are you saying it wasn't specific in amount or it wasn't specific in method?
In method, yes.
Okay. I disagree. This is a standard order, and the vast majority of everyone I've ever dealt with that deals with these.
This is a teachable moment in courtroom procedure. The judge clearly lays out the rules. Without required payments, the dispossessory order stands, and D23 LLC is entitled to possession. It underscores how structured and precise legal processes are. One missing payment or incomplete documentation can determine the outcome. As viewers, you can appreciate the balance the judge maintains, giving Ms. Ballard the opportunity to produce evidence while also enforcing the rules. It's a clear example of how legal strategy, compliance, and procedural rigor intersect in real time, with very real consequences for both parties involved.
Number,
I mean, ma'am, I object. I object. I mean, it's there. Under what law does it say that it is not a legal payment, a legal tender?
so in all honesty,
Respectfully.
I don't know the answer. I could do some research and find the answer, but Ms. Ballard, it's your obligation as the movant to provide the information that the court requires in order to understand your case, to accept your case. And you have not provided me, more importantly, with any documentation or a legal citation that would provide me with some sort of basis to accept your providing me with this note of exchange as legal tender. As I said, my understanding of the law is that a note of exchange is not legal tender recognized in the United States, and therefore it does not constitute a payment.
You have not provided me an answer, but I'm not trying to be respectful. You're
Ms. Ballard,
me and not properly.
you are continuing to speak, and Ms. Ballard, stop. I understand that you do not like the outcome. I understand that you believe that legal tender or notice of exchange that you gave me should count, but it does not. The answer to this question is that the order that was entered says that tenant must make the following payments into the court registry, and there were no payments made into the court registry, and the filing that you submitted does not constitute a payment of legal tender into the court registry and does not constitute compliance with the order that you make a payment into the court registry. And therefore, the case is going to be dismissed. Case number 2023 CV 390111 will be dismissed for lack of payment. Anything else that the parties need?
Wow, what a case. To summarize, Natasha Ballard challenges D23 LLC's claim, asserting priority interest and denying tenant status, while disputes over proper payments and documentation complicate the proceedings. The judge carefully navigates procedure requirements, evidence review, and legal obligations, emphasizing how crucial documentation is in property disputes. The key takeaway? In court, details matter, proof of payment, proper filings, and adherence to procedure can make or break a case. If you found this as fascinating as we did, hit that like button. Share your thoughts and comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.